Thank you for joining me. Today, in this video, we're going to break down Courtney Clenney's Second Amendment motion for reconsideration of bond. Although this would be the third filing, it is the second amended motion considering the reconsideration. In this latest filing, dated December 3rd of 2025, Courtney Clenney's defense team submits a Second Amendment motion for reconsideration. And what this motion argues is straightforward and deeply significant. Clenney has been held without bond for over 3 years due to a series of government-driven delays, breaches of attorney-client privilege, and there is newly discovered evidence that undermines the state's theory of second-degree murder. The defense now asks the court to reconsider its previous rulings that denied her bond, arguing that the legal landscape has fundamentally shifted. A little background first. Well, Courtney Clenney is charged with second-degree murder in the death of her boyfriend, Christian Obumsali, that happened on April 3rd of 2022, inside her Miami apartment. The defense is laying out critical context. They state that Obumsali was not on the lease and had been asked to leave multiple times. In the days before his death, he was reportedly escalating in aggression, with building staff and neighbors calling police more than once. And on April 3rd, according to Clenney, she threw a knife in her self-defense after he allegedly attacked her, a version she has repeated consistently since her first police interview. Despite this, Clenney has been held without bond since her arrest on August 10th of 2022, when a SWAT team took her into custody at a rehabilitation facility in Hawaii. The government delays and alleged misconduct, a major theme of this filing, and its role in delaying Clenney's case by almost 2 years. The defense details it as a series of serious breaches. Number one, the overbroad iCloud warrants targeting her parents. In 2023, Miami police sought warrants for the entire iCloud accounts of Courtney's parents, reaching back 17 months before the incident and 7 months after Clenney was already incarcerated. These warrants pulled in massive amounts of irrelevant and private data, according to the attorneys. Number two, review of attorney-client and work product communications. Law enforcement and the state attorney's office assessed defense strategy documents, private group chats between Clenney, her lawyers, her parents, and the defense team, emails and attachments that were specifically and explicitly labeled as privileged. These communications included a document clearly titled Courtney Checklist of Things to Do, privilege.docs. Yet an assistant state attorney still opened it. The court later ruled that these communications were privileged and should never have been reviewed. Number three, they list additional breaches. Assistant State Attorney Khalil Quinnen reviewed privileged text involving discussions about a laptop in possession of the Clenney family, then claimed he immediately stopped after realizing what they were. A third-party public records request later revealed he had also accessed other privileged emails, contrary to his statement. Law enforcement allegedly instructed a witness to delete photos and video taken at the scene before police arrived. Number four, resulting delays. All of the above issues led to motions to suppress, motions to dismiss, motions to disqualify the state's attorney's office, depositions of prosecutors, and lengthy litigation over privileged issues. Altogether, these controversies stalled the case for 18 months. All listed in the filing. We now get to the new evidence supporting self-defense. In this filing, the defense argues that the weight of the evidence has dramatically shifted since the original Arthur hearing where the bond was denied. And these key developments include a witness who saw Obumsali physically attacking Clenney earlier. There was a neighbor, Arthur Cupp, who lived across from Clenney, and he told the police on the day of the incident that he witnessed Obumsali pummeling her in the past. This witness was known to the state, however, was not disclosed to the defense before the Arthur hearing. There were multiple statements corroborating domestic violence. Security and building staff reported seeing Obumsali charge at Clenney, Clenney begging for a restraining order, calls to police made within 48 hours of the fatal incident. All of this helps support the defense's battered spouse theory. And then there's the expert evidence on the knife throw. Two defense experts, including a knife throwing specialist, concluded the knife could indeed have been thrown, striking Obumsali with the angle and depth described by the medical examiner. And the state's medical examiner admitted he had no expertise in knife throwing. The defense put together a video, and we watched that in a previous hearing, of the knife throwing expert throwing a knife at a pig carcass. It took multiple attempts, but one of them did actually land. There's also the expert testimony that a 911 was called immediately. Dr. Millard Webb, a medical examiner, recently concluded for the defense that Clenney may have called 911 almost immediately after the injury. This directly contradicts the state's earlier claim that she left Obumsali to bleed out to his death, which actually led to the state's claim of charge of second-degree murder. That claim was central to the state's narrative of a depraved mind, which was required to make that charge of second-degree murder. Let me get to their legal argument for the reconsideration of the bond. Because under Florida law, once new evidence or substantial changes arise, a defendant is entitled to a reconsideration of detention status. And Courtney Clenney's defense is arguing that the government misconduct has caused extraordinary delays, violating Clenney's right to a speedy trial, and that there's new evidence, both factual and expert, which undermines the state claim of second-degree murder. They claim that the charge is more appropriately manslaughter, which is a bondable offense. Prior bond denials relied on improperly reviewed recordings and incomplete discovery. The defense argues that the state no longer meets the requirement of proof evident presumption great, the standard needed to deny bond in a second-degree murder charge. The defense also accuses the prosecution of misleading the court by claiming that Clenney fled jurisdictions when she had no travel restrictions and was seeking rehab. She concealed money when in fact her father was paying her bills, including legal fees. She posed a danger to the community despite no history of violence outside of this relationship with Obumsali. Her home has since been foreclosed. She is now essentially without financial resources, reducing any risk of flight, according to the defense filing. And so this filing also proposes that the court set a monetary bond for Courtney Clenney, that she be put on home confinement at her family home in Texas, that she be required to have GPS monitoring, and mandatory outpatient treatment for her PTSD and substance abuse, and released into custody of her attorney to transport her safely to and from the courts. And in conclusion, this actual motion paints a picture of a case that's been stalled by prosecutorial overreach, mishandling of privileged material, misrepresentations in court, and newly emerging evidence strongly supporting self-defense, which had not priorly been notified to the defense. And the defense argues in this motion, 3 years into her incarceration, that Clenney must finally be granted a bond that reflects both the law and the true weight of the evidence. I find this very interesting because I actually think they have a shot here the brief was very well written. And if indeed evidence had been destroyed, there was misconduct, ASA Quinlan did not actually disclose everything that he went over, this all looks bad, but it'll be up to the judge. And on December 18th, this will be reviewed again. Please check out the video link below to the recent court hearing where this was all put forward and the dates were issued on when the prosecution has to actually address several of the motions that are outstanding. There is a bit of a delay, but this one seems to be addressed on December 18th. There's also a motion to dismiss pending, several other motions in limine to actually suppress evidence, some suppression of evidence that they feel was acquired erroneously. I welcome all comments, and I'd really like to know, what do you think? Do you think she has a shot at getting bond after all this time in jail? Do you think the third attempt to release her from prison pending trial is going to work? It does seem like the landscape has changed. And this does look like the best effort to get her out and the one most likely to succeed if there is a chance. We shall see, though. I look forward to December 18th. I hope you'll join me. In the meantime, please let me know. Do you think it'll work? Comment below on anything about this case or any of the other cases I'm following. I love to hear from you. In the meantime, if you do enjoy the content, don't forget to like, share, comment, and subscribe so you get notifications on my next drop.